everybody. I'm delighted to be here with my colleague in the law school, Dr. Iloka, and tonight, this evening, or this afternoon, what is it now at 5 o'clock? So dark, it feels like tonight in any event. We're going to discuss charity law and for half an hour or so, and then open the floor to questions. And if any of you have any questions or comments or insights, then please do share them with us. I guess I want to say a general word about our webinars firstly before a little more about Uche. This is the end of our last one, obviously this year. We're getting close to Christmas and the end of the year, and at the end of the second year of webinars that we've given in the law school, and I've hosted with Uche when I was the speaker. He was the host when we were speaking about extradition law or human rights or citizenship deprivation, which we have in the past that I know something about. And I think they've gone very well. And I just wanted to say thank you for coming, and to Heather and Uche at the outset for taking part. And the plan for next year is pretty well finalized. We don't have dates set, but I've got some of my colleagues in the law school and different subject matter, climate change and energy transition, or two of them that are tentatively organized for the spring of 2022. And as soon as we do get that, I get that finalized with Heather, we'll share the word. So I encourage you to please come back and oh, she's disappeared. Come back and take part, and spread the word with your colleagues or anybody else you think might be interested in attending. You know, this is organized kindly by Heather and alumni for our graduates, but also for current students, for anybody interested in our research and scholarship in the law school. So to my mind, and I think our speakers, the more the merrier. So, you know, don't be shy in spreading the word if you know of anybody that might be interested in any of our subjects coming up in 2022. Okay, that's that said, as I said, Dr. Iloka Uche, my colleague in the law school, is an expert in multitasking, and he's got various areas of expertise and indeed professional practice, as well as academic research. And he in his previous career was a solicitor in England for some time, practicing charity law, and then came up and read for his PhD roughly in that area. Certainly touched on charity law and international law sort of jointly, and has kept up some of his, when time allows, some of his is practice in charity law. So he certainly has his finger on the pulse of charity law, and can speak of it not only from an academic legal perspective, but also, as I think we'll come to later in the webinar, of a practical applied. You know, how's the law? Academics like me who live in a so-called ivory tower, I can speak about the law for hours, but when you give me a practical question about, well, what happens in practice, sometimes I have to do a fair bit of thinking and ask a colleague where Uche is he got a foot in both camps. So he certainly can speak with expertise and authority on not only the law in the abstract, found on Westlaw, but how it would apply in a board meeting of a charity, for example. Okay, so welcome, Uche. Thank you for coming along.
Thank you very much, Paul. Thank you for having me. Good evening.
Okay, so we'll get stuck right in, and I'm gonna, as usual, fire Uche some questions in and around charity law, and where I can. And we have actually jointly written a little something on a case in the Scots Law Times on charity law, about a case relating to the historical site of New Lanark several months ago. So I do know a little bit about that, but Uche was guiding me for sure about the substance of charity law. Okay, to start off in more general, in a general sense, and then move to some specifics. Clearly, charities are vital in the United Kingdom, and perhaps even more so than some other countries. I remember speaking to one of my former classmates from Denmark, and said it was really notable how the UK not only has a charitable sector, but in fact relies on it. And his view, and I don't know what I haven't said to Uche, I was going to talk about this, but in how his view, when Denmark, they have some charities, but they're sort of extras. But the UK is such, maybe the restrictions on public spending or austerity, or I'm not sure why, or just even the traditional nature of the third sector led to society and individuals relying on the charitable sector. It's not just sort of icing on the cake. It's a layer of that cake for sure. The substance of social welfare of the welfare state is reliant or beholden on the charity sector, and of course how it functions. The charity sector charities receive donations from the public, and becoming a charity, receiving public donations, is the origins, the lifeblood of charities. It clearly raises another question, a really important one. Well, that's all well and good, and indeed excellent and necessary, but then how are charities regulated? Thankfully we don't. They must do a good job, but placing donations in the hands of individuals certainly raise the possibility in theory of somebody going, embezzling the money or going abroad, or acting in a way that they shouldn't. So Uche, just to start off with, if you could tell us a little bit about the charitable sector and how the government oversees or governs the charitable sector.
Yeah, thank you very much, Paul, for that question. And indeed, you're right. The charity sector is quite a relevant part of the society today. So normally we are used to the public sector and the private sector, and a lot of people are somewhat oblivious as to the third sector, which is essentially the voluntary sector, wherein you have charities playing a significant role in that sector. And usually, because lots of money are put in the hands of these organizations by donors, by members of the public, it's essential that the government keeps a keen eye on it and see that there is some sort of clear regulation. So there is indeed some regulation of the sector across the UK. Now, although what is unique about charity law is that it's somewhat distinct across the various parts of the UK. So you have a separate regulation in England and Wales. You have the Charities Act of 2011, which regulates the sector. But in Scotland, you have a different one, which is the Charities and Trustees Investment Act of 2005. And also in Northern Ireland, you also have the Charities Act in Northern Ireland of 2008. So these are essentially the main laws that regulate it. But again, when you're looking at regulating the sector, it's not just about these laws, which then bring about a regulatory body like the Charity Commission, or in Scotland, you have the Office of the Scottish Charity Regulator, often referred to as OSCR. And in Northern Ireland, you have the Charity Commission for Northern Ireland. So besides these regulatory bodies, depending on the type of charity it is. So if it is a charitable company, then it becomes dual regulated. So it's regulated by both the Charity Commission and also the company's house, so the registrar of the company's house under the Companies Act of 2006. So it depends. And also you also have the HMRC, which is regulating charities for tax purposes as well. You also have the Information Commissioner's Office regulating charities in relation to how they deal with data. So there is a cross-pollination of regulators, but the core regulators would be the Charity Commission, or the Office of the Scottish Charity Regulator, or the Charity Commission for Northern Ireland. So those are the three core regulators in the UK. But depending on your legal form, you could be dual regulated or just regulated by just the Charity Commission. So it depends on that as well.
Well, thank you. Very, very interesting indeed. I mean, and come to think about it, I think I was aware, but you say a charitable company, in a way, is that an oxymoron? Is that the term or something? Either you're a charity or a company, or isn't it a contradiction of terms? But obviously not, because you can have charitable companies. Maybe a company created in limited, or assumed by its articles of association to act in charitable purposes and not profit making or something or other. I know that's a different subject, but I guess I was just
Yeah,
thinking
but can I just speak
charitable
briefly to
company.
that, Paul? That's a very good point you made. And indeed, it seems like an oxymoron, a charitable company, but indeed, there are different forms. So you have charitable company, you have charitable trust, and you have the charitable incorporated organizations. In Scotland, you have the Scottish Charitable Incorporated Organization. These are various legal forms a charity can take. Now, in reference to a charitable company, is really in relation to the whole concept of a separate legal personality. Now, with regards to a charitable trust, they do not have a separate legal personality. So in a sense, the trustees have some personal liability to that extent, but often they have to take on some level of insurance to cover that trustees liability. It's often referred to as a trustees indemnity insurance. But for the most part, with a charitable company, it's the same corporate veil principle with a company's law that applies. So there is a separate individual. Now the trustees now have two titles, if I could use that term. So they are referred to as trustees when they're being regulated by the Charity Commission, but when they're being regulated by the company, the company's house, they're referred to as directors. So it's essentially the same thing. But even though it's a charitable company, they cannot make profit for, you do not have like shareholders as such. All right. So they cannot make profit for its investors or owners or any of all that. You essentially make profit for the public in a sense. Everything that you do is really to the benefit of the public.
Very good answer. Thank you. Enlightening. I mean, the way you explain it seems so sensible, which I assume it is. I guess even because you wouldn't want to, I think I have a hard time somebody volunteering to become a trustee of a charity if they thought that a delict or some other issue happened in the course of the charity's activities, and the person could be personally liable. I'm going to lose my house by virtue of as a consequence of volunteering for to sit on the board of a charity. So very interesting. I'm sorry for firing that question to you. I know we haven't spoken about that before. Okay, now we can move on. Thank you for that. These three regulators created by statute, existing in the three jurisdictions of the United Kingdom. Excuse me, England, Wales, Scotland, and Northern Ireland. So then that's all good. There's a regulator at one level. Then you're going to have, I assume, quite a number of charities, and maybe you can mention the scale of the sector when I'm done my long-winded question. But who has responsibility for the compliance? So there's the law in these various statutes, and they created this body to oversee them. Who has responsibility within a charity to ensure that what that charity does is adhering to the law and not maybe acting in a way that's out with the rules governing charities?
Yeah, really, in relation to that, the straightforward answer to that is that the trustees are ultimately responsible for the governance of the charity, and as such, they're held liable if they have made any poor judgment or if they've acted in a way that was not in the interest of the charity. So essentially, they are responsible for the governance of the charity. But when you look at it holistically, everybody part of the running of the charity have a role to play to see that it meets its essential objectives. Now, two concepts make up what it means to be a charity in the UK, two core concepts, and they are the concept of public benefit and charitable purpose. And when you merge these two concepts together, you get the whole concept of stewardship, and that is the role of the trustees. So the trustees are essentially stewards for the charity, and they're responsible to see that every activity that a charity does is a charitable purpose. Now, when we refer to a charitable purpose, it's not about a generous act. All right, there's a difference between being charitable in daily conversation and being charitable legally speaking. Now, for it to be a charitable purpose, it has to be provided for in the law. Now, various sections of the law provide a specific number of charitable purposes that the trustees, when they set up the charity, are custodians of those purposes, and they have to further those purposes for the benefit of the public. So essentially, this is the role of the trustees in the function of a charity. So the charitable purpose in England, for instance, there are about 13 specific charitable purposes. So this is usually what would be the difference between a charity and maybe just an NGO or a voluntary organization, right? Not all voluntary organizations are charities, but all charities are voluntary organizations, right? For you to be classed as a charity, then you must be furthering one of those charitable purposes. And then secondly, you must be doing it for the benefit of the public. Now, the concept of public benefit is one side of a coin. The other side of the coin is a restriction of private benefit. And this is the role of the trustees. So the trustees have powers and responsibilities to see that there is no private benefit gotten in the function of the charity, except it's incidental to the carrying on of their activities. So this is in a nutshell, the function and the role, the responsibilities of the trustees, and to that extent, they have to act in good faith and so on and so forth.
Okay, so the charitable, what general categories of charitable purposes are listed in the legislation in each jurisdiction, is that right? In Scotland, England, and Northern Ireland?
Yeah, so different jurisdictions have their categories of charitable purposes. In Scotland, there's 16 charitable purposes
Okay.
listed, and you find that in the 2005 Act. If you read from Section 7, it explains the 16 charitable purposes. In England and Wales, they're 13, and in Northern Ireland, they're 12. But when you look at it in terms of the content of what has been listed, they're essentially the same thing, except that in some jurisdictions, they've only just broken it down more, but it's essentially the same thing. Yeah.
I'm just thinking, I know again, I'm going off script a little bit, but this could be a matter of some controversy. I remember the famous European Union case about free movement of people, where a Scientologist was denied entry into the United Kingdom because at that time it was thought that a Scientologist was not conducive to the public good, maybe in immigration law. And I don't know if Scientology a charity in the United Kingdom? Surely must be some dispute or controversy arising about certain religions and other causes, for that matter, being accepted as charities. Is that right?
Well, it depends. So one of the oldest charitable purpose, when you look at the history of the evolution of charitable purposes, starting from 1601, where you had the Elizabeth Statute, the 1601 Statute, which had a preamble to that statute, which introduced the whole concept of charity law. And that evolved over time. And then you now had a case called the Pemsel case. And that Pemsel case now introduced 4 broad headings of charitable purposes. And the 4 broad headings that they came up with was the advancement of education, the relief of poverty, and the advancement of religion. Then the 4th one was any other thing that is considered charitable in the context of the community benefit and so on. So there's always that last purpose that is almost a window for it to grow. Yeah, so the advancement of religion has evolved over time, and in a sense, if Scientology is considered a religion, then it will fall under that umbrella of charitable activity. So it depends on, I don't know much about Scientology, but I believe it is a religion, and if it is considered as a religion or something along those lines, then it would be classed as a charitable purpose on the either of the any of the jurisdictions, because those 4 purposes have stayed till date and they've evolved. Yeah.
Okay. Thank you. I know that's another question from left field. I'll stop doing that. But I just remembered that case because it was controversial at the time about, it was just in contrast to the EU's, it wasn't charitable law, it was EU free movement law, Okay, but we'll move back to charity law per se. And so we have benefit, it is critical about what the charity must act towards a public benefit and not, a private benefit. Would you explain a little more about what a benefit, what form of benefit could take? Well, what is benefit?
So benefit, the whole concept of benefit, the charities can provide benefits in different forms. And some of them could be very clear and measurable, and you know exactly what it is. So for instance, if you're setting up a charity to relieve financial hardship or help the rehome the homeless, or setting up a church which is advancing Christianity, these could be clear and they could be described as tangible. Other times, it could be intangible benefits and more difficult to measure, but it still has to be identifiable. So, like the benefits of education, for instance, or you want to promote historic buildings. So the benefit element has to be beneficial in a way that is identifiable and capable of being proven by evidence where necessary. And it's not subjective. It cannot be, you cannot say it's beneficial because you say it is. It has to be objectively so. So it's not based on personal view. And then the interesting thing about the benefit is, and we were talking about the Lannex case, and this is where this came up as well, where in measuring the benefit, you have to measure it against any detriment or harm that occurs in furtherance of that benefit. And such detriment or harm must not outweigh the benefit. Now, this looks a bit long-winded, but I can break it down. So if it costs a lot to run the charity to a point that a significant portion of the donations are going into administration of the charity, and just a little is going for public benefit, then the position of the law is that the detriment is far more than the benefit. So that means it's costing too much to deliver on the charitable purpose or the benefit to the public. And that was the case with the kids company case. The lady who was very colorful, powerful, influential leader of a charity down in London, around Peckham area. But when amongst many other things, one of the things that was found was that there was so much money going into the administration and the running of the charity at the detriment of the beneficiaries in the end. So in measuring benefit, you have to measure it against the cost of that benefit, and the cost must not outweigh the benefit. All right.
Okay, is that like public benefit against private benefit? Is that what we're speaking about, or public benefit against, because administration private benefit, or maybe it is.
Yes, so private, not necessarily measured against private benefit. So administration is cost, right?
Okay,
Is
cool.
running cost of getting the charity, and it's fine. It's good use of charitable funds to get admin going. Where it becomes a problem is if you receive £100 and you spend £80 on administration and 10 and £20 to the beneficiaries, then you say that the detriment or the harm or the cost of that benefit outweighs the benefit, and in that sense, it's not going to fly as a good charity.
Okay, so we've got, as you say, these are two maybe core elements. Charitable benefit and a charitable purpose, pardon me, and public benefit. So those are the building blocks of charities and charity law.
Yeah, those are the core aspects of charity law. That's why charities depend a lot on volunteers, because it reduces cost in order to keep the charity flowing. Yeah.
Yeah, well, I think that's probably the most of our day-to-day experience with charities is walking down the High Street or Union Street or wherever we are, and seeing, the various charity shops that run for all sorts of charities.
Yeah.
As a public manifestation of them. And even then, I think the cost that they must incur in some of those bigger charities must be massive. I know maybe the rentals are not as high as they used to be for high streets, but just even the property expenses must be huge.
Yeah, that could be high, but the thing is, when you look at it holistically, when they do, the good thing is, because charities are essentially at the beck and call of the public, right? The public are the bosses of charities, essentially, And everything that the charities do, they have to report it annually, and they do what is called the trustees annual report. That has to be, that has the accounts parts of things, but also the narrative as to the activities that have gone. Now, in that report that is reported annually, you almost get a graphical picture of how much funds are going to the beneficiaries, and how much funds are going into running costs of the charity. And it's, you could say that it's usually a smaller portion. Now, for all of these big charities, when you compare it to the amount of good that they're doing and the amount of beneficiaries that are getting something out of it, it would, I don't know for a fact because I don't have all their books, but I believe it would dwarf the cost in the end.
And where are these? Would these be found on the, just my own curiosity to have a fish around one day? Are these found on the charity regulator's website or on
Yeah,
Company's House, or where would I, if I wanted to see, is it, I don't know, Mary Curie Cancer or some, if I wanted to look at a specific charity's
yeah.
annual report, where do you find them?
You just go to the website. So it depends on, again, it depends on the type of charity. So if you are a charitable company, then you can find your reports both on the Company's House website and on the Charity Regulator, Charity Commission website, or the Office of the Scottish Charity Regulator website. So they have those details there, including details of trustees and so on and so forth. Although in Scotland, some details are removed, but the essence of the charity, the cost, and how it's operated over the year is still there. So you can find it on in the regulator's website, because one of the objectives of the regulator is to see that they are able to maintain public confidence in the sector. And for them to do that, they have to be open and transparent and demand the same from the various charities within the sector. Yeah.
Yeah, well, that's a very good point. I mean, and we'll maybe move on to responsibilities and liabilities. Just my next question, but clearly that's absolutely essential for the charitable sector, isn't it? I mean, I know there's been a couple bigger scandals, global scandals in any event, and you did mention this kids company
Yeah.
episode, and
Yeah.
I don't know much about that, so I'm not saying that was a scandal or anything,
It was a
other
huge
than it was
scandal.
in the newspapers. But
It was a huge scandal, Paul. It was, just Google it. There's a lot about Kids Company.
okay, and so that could affect, and a big, developmental, was it? I forget the name of it. It was a UN charity or something working, or I don't even know the name of the charity in developing countries, and there's some, abuse of children and sexual
Yeah.
misconduct, and just a huge, and that sort of activity could be hugely harmful, because who's going to want to make a donation if they think that they're not helping, but in fact maybe actually harming, as a result. So that's, I mean, that's just an observation. So maybe I want to move on again, maybe ultimately to ensure that doesn't happen in one sense, or the responsibilities and liabilities of individual charities. So obviously we save the day to say people volunteering in the charity shop, but then there's the 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 trustees, which we mentioned, and what's, how are charities sort of organized, kind of akin to sort of company law, which has a board of directors and and so forth. What are the responsibilities and liabilities of people uh, stewarding charities?
Okay, so like I said initially, the bulk stops with the trustees, and so they are responsible for the governance of the charity. But in terms of how they do it, and their functions, their responsibilities, they have their statutory responsibilities. And in the 2005 Act, if you look at from sections 66 to 70 of the Charities and Trustees Investment Act of Scotland, it talks about the duties of the trustees. But beyond these statutory responsibilities, the sector have come up with a code of governance, and these touch on a few things to ensure that the charity essentially is effective and achieves its role. And in Scotland, you have about 5 core principles in the code of governance. So you have the organizational purpose, and this is a crucial part. I mean, I was at a conference a couple of weeks back, and the speaker was talking about a research that was done that showed that about 80% of charity trustees don't know their role, don't understand why they are in that function. And this was a research done by, I forgot the name of the researcher, but it was credible. So the point is, That's why it's there as the number one, in both in Scotland and in England and Wales. It's the number one principle in their code of governance, having clarity as to the purpose and the values of the organization that it chooses to follow. So that's a crucial part. And when you talk about a purpose, it boils down to the whole concept of the charitable purpose and the concept of public benefit. So the trustees have to have clarity as to these two concepts. You know why? You mentioned earlier, by way of an observation about charities traveling, maybe charities that have operations overseas and they get engaged in scandals. And a common one, which most people would be aware of, is the Oxfam crisis, where so that cost millions of pounds to the charity. I mean, it was found that at over 7,000 donors left Oxfam as a result of that scandal. Now, the concern there is that if you're looking at the amount of money that left Oxfam, there's a great chance that that money did not just leave Oxfam; it probably left the entire sector. People just removed their monies and didn't give it to another charity, because the trading currency within the sector is trust, and these code principles and the governance code, whether it's organization purpose, leadership as well, a board that is clear about its role, its responsibilities, and of course, the board behavior. So where people are not just in the board and just docile, or there has to be that level of openness and mutual respect, not one person dominating the affairs and direction of the board, and the effectiveness of the board, the control. So these are some of the codes, the principles there. Now, all of these principles, if you look at it, whether it's in England and Wales or in Scotland, they're all geared towards one thing, and that is safeguarding its reputational capital. Because as soon as the reputational capital of the charity begins to deplete, that's how its funding depletes. That's how its ability to be effective within the sector and within its chosen area depletes. And that's how the charities run out of market. So the whole point is trust, safeguarding trust. And these codes, in terms of how they carry out their responsibilities, apart from the basic laws of trust that apply in generally about trust law, about acting in the best interest of the charity, not making personal profit, and all of those things. Following these codes, they're all geared towards safeguarding the reputational capital of the charity as a whole.
Yeah,
So
well, thank you.
Yeah.
Sorry, sorry for interrupting, but just get me thinking that maybe somebody in the past, or I think occasionally I've seen calls or adverts for volunteering as a trustee of this group or that group, and I've thought about it, but I've never done it. But so you're suggesting it's really a lot more, I'm not saying it was ever an unimportant role. I always thought it was an important role, but complicated or complex role than perhaps one could imagine than just giving your general advice on what you think would be in the best interest of the charity.
Definitely. And one of the good, when you're looking at the code of governance as well, one of it is having a good board effectiveness. And in relation to board effectiveness, which is one of the principles there, it's about having the right mix of skill in the board. So it's not just about being there and providing you advice from time to time. The standard of care as a trustee has to match whatever your professional standard is. Whether if you're a lawyer, then they expect that kind of standard of care in the discharge of your responsibilities as a trustee. If you're an accountant, there's a higher level of standard that is expected from you. So essentially, it's not just coming to I'm a member of the board, and some of the bad habits, and this is popular around the UK. The bad habits that you have lots of board members do: they go for meetings, they don't read the board papers, they just talk through it. There's a significant number of statistics that favor this position. So the point is, it's a complex role that really requires you to understand your responsibilities first and know that you're supposed to be acting entirely in the best interest of the charity and with some great deal of prudence. And because if a trustee has acted without prudence and and acted negligently, even if it's a charitable company, the trustee could be personally liable for those actions. So they need to understand to that extent.
Oh, well, that's quite a good, well, very good point. Is I mean, I say we should all act with considerable caution before we undertake such obligations, I suppose. But I guess that could be. Well, I mean, I don't want to be too, dramatic, but I mean, it could hurt charities if people are, if they're not getting enough expertise or people to volunteer because they're worried or anxious about the consequences of becoming a trustee. But maybe this leads me to my next point about, so if you are advising the board of a charity or indeed trustees themselves how to act, and indeed an element of this would be managing conflict of interest. If somebody is a business owner, a lawyer, an accountant, or whatever, clearly there could be possible conflicts of interest arising uh, in their contribution. What advice would you give to the board on that issue?
Okay. First, one of the objectives of the regulators, whether it's the OSCR, that's Office of Scottish Charity Regulator, or Charity Commission or Charity Commission for Northern Ireland, these are the three main regulators in the UK. One of their main objectives is resourcing charities, right? And as a result, in relation to, I'm coming to the question of conflict of interest, but just to the premise of the question about people could be concerned about taking on the role because of how complex it is. The regulators are there to support, and they're not really there to catch people doing things wrong. They're there to help you get it right if things are wrong. So they don't always come with the intention to punish or to get people pay for whatever they've done wrong or decisions they've taken that was just not right. So from that standpoint, there is a lot of support resources from the regulators to help people who considering being a board member and have no experience whatsoever. There's a lot of support from that standpoint. And then, of course, a good board would have a detailed induction. Now, coming to the question of conflict of interest. Now, the presence of conflict itself is not necessarily a bad thing. The bad thing is the bad management of the conflict. Now, there are three things that are important when you're dealing with conflict in relation to charity. Number one is to identify the conflict. The second is to prevent or manage it. And then the third is to record it. Now, three of them are so crucial. Not one of them is less important than the other. And that's why it's important when charities are coming to a board meeting, they're having a chat. One of the first things that should be on the agenda should be a declaration of conflict. So if you've looked at whatever it is that is being discussed for the day, and you feel that you're conflicted one way or the other, perhaps your relative is one of the directors in a company that is going to be supplying stationery to the charity. That is conflict. So you have to be able to identify what have conflict, because like I said, the whole concept of public benefit is just one side of another of a coin. The other side is a restriction on private benefit. So trustees are not supposed to get any private benefit in the function of the trustees except as provided for by law. And so you have to identify the conflict and then you prevent it. Now, sometimes it is impossible to prevent it. Sometimes, even though there is a clear conflict of interest, but it is in the best interest for the charity to act in that way nonetheless. So perhaps a trustee may be, let's take the instance of a stationery, for instance, and this trustee who has a relative who is supplying stationery is providing the most competitive price and the best quality, right? So that is actually in the best interest of the charity to patronize that person in that instance. So it has to be managed well that the conflicted person is not part of the decision-making process. So in such a scenario, whoever is conflicted should be exempt from that decision-making process. And that's why this sort of dovetails into the number of trustees you have. And that's why it's always good to have maybe at least 5, right, trustees. So there's still a good number of people that could make a decision in the absence of one trustee who is possibly conflicted, right? So you have to record how you took steps to mitigate whatever risk that would come, and that ultimately, whether or not you follow you act carried on with the decision that's conflicted or not, you've acted in the best interest of the charity. And that leads to the third thing. For you to show that you've actually acted in the best interest of the charity, you have to record it. And that's why the minutes of the meetings, the recording of how the conflict was identified, how it was managed, it's crucial. So identify, prevent, and record. That's the best way to manage issues around conflict.
Excellent, excellent. Thank you. And then our final question before we open it to questions, time's passing very quickly, is what happens if something goes awry? If there a conflict isn't prevented, or some other something else happens that's contrary to the law or the code for that matter. What happens? The regulators step in. It could be the criminal consequences, civil what would happen?
Well, there's a wide range of things that could happen when if the ball drops. A wide range of things, but it depends on the gravity of the situation also. But an extreme case of what could happen is really detailing what the powers of the regulators are. So a regulator could just scratch a charity from its register. That means the charity just ceases to exist. That have powers to get a trustee to no longer be a trustee for a period of time. And this has happened over time. And there was a case September last year, I think it was 2020, it was Believe in Magic. It was a charity that helped children, was something around playing with children and all that. But they just dropped the ball in different areas. They were dealing with cash, and so there was no clear records of how finances were being moved. They were late on filing their reports, which they needed to do, and a number of other things that happened. And in the end, what the Charity Commission did was remove the charity from the register, and so it was no longer in existence. And all its assets, they have the power to transfer the assets to a like charity of their choice. So all the assets that a charity had in the past, they transferred it to another charity, I think around 3 or so charity. So they had that power to do that, because the regulators have somewhat of a quasi-judicial role. And so they, in a sense, can exercise the powers or like a court would. And if you're not happy, then you can appeal to the first tier tribunal. But the point is, they have such powers to freeze the bank account. So if charity assets are with a third party, they have powers to restrict the use of those assets by the third party. So they have a wide range of things that they could do, but they do not like to bring a hammer to kill a mosquito. They like to be proportionate in the way they deal with issues. So if an issue is not it's bad, but it can be managed and can be restored, they would rather try and fix it rather than go to this extreme, which I've just described. So that's really how it is, because objective of what they have to safeguard the public confidence in the sector. They have to see that the trustees stay compliant and so on. So they can do it a lot of things. They can appoint an interim manager, for instance, to run the function of the charity if something is going wrong as well. So this is just there's a whole list of several things, but yeah, I think this is a good enough picture.
No, thank you. I think overall you've given us a great picture of charity law in a nutshell, maybe, to put it over just over 40 minutes or something, and touching on some of the most important aspects of the regulation, the principles of charitable purpose and public benefit, and the regulatory schemes and the position of trustees managing charities.